This video should serve as a brief but thorough oral overview of the lawsuit between Melinda Scott and Joshua Moon, the owner of Kiwi Farms. We're not going to cover their entire legal saga because this is a story that spans several years and several lawsuits and an ongoing love affair that I have no doubt will continue far into the future. Rather, we're going to focus on the most recent lawsuit that was filed on July 8th of 2020 and culminated in dismissal on August 30th of 2021, meaning this lawsuit from start to finish took over a year just to be dismissed for the lack of merit that it had. Now, we're not going to cover every single document in this lawsuit because many of the documents were filed by Melinda Scott, who is filing in forma pauperis, something we'll describe a little bit later, but basically means she doesn't have to pay for anything. So these documents were filed with the purpose of increasing the cost and duration of the litigation, because as a personal theory, I happen to think that Melinda Scott is addicted to the legal process, some affliction that I think covers quite a few random eccentric individuals, another one being Russell Greer. I feel like people get into this idea that they are able to enforce their rights through pro se representation in the legal system, and then they get literally addicted to it and cannot stop themselves from filing more lawsuits. That's why I also believe that we will likely see another Melinda Scott versus Joshua Moon lawsuit in the future, even though that would probably be a very bad decision for her. I don't believe she'll be able to help herself. With that said, we're going to start jumping into a couple of the key points in this lawsuit and telling the overall story of it as best that I can. And if you wait around to the end, I'll give you a nice little tidbit that is just the cherry on top of this beautiful ice cream sundae. All right, stick with me. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, go ahead, hit like, hit subscribe, turn on your notifications. Make sure you don't miss any videos. All right, here we go. So it's a little bit important to set the background on this particular cause of action. This cause of action's genesis is a CPS, a Child and Protective Services call that was made against Melinda Scott, allegedly by a user of Kiwi Farms, but importantly, not allegedly by Joshua Moon. This is what prompted all of this lawsuit. And in the process of this, Melinda has sued not only Joshua Moon, but 4 unnamed John or Jane Doe defendants who are allegedly users of Kiwi Farms. She has also sued the Wise County Department of Social Services, which is the office that actually undertook the response to the Child Protective Services call and allegedly went out to Melinda's house and investigated to some extent this thing. Now, we've seen things like swatting and Child Protective Services being weaponized against people on the internet before. It's not an activity I condone, but it's also, I don't know who or what engaged in this activity, and you can't really tell the internet what to do. They will do these things, they being people on the internet. And the Kiwi Farms, it's important to note, is not a monolithic entity with a singular objective. Anybody can join Kiwi Farms so long as they have an email address and choose to register, and at that point, they're in there. There's no real way to control or determine the outcomes of the activities of one or more persons on Kiwi Farms, and there's no way to lump them all together as a singular entity. Heck, within each individual thread, you'll find significant disagreement. But this makes me think maybe I should back up for people who are not entirely familiar just a little bit and explain that KiwiFarms.net is an internet message board that has been around for quite some time. And the purpose of this message board shifted from watching one person, Christopher Chan, to watching the entire internet. And it became a board where people could discuss celebrities or e-celebrities or subjects or shows or lawsuits or whatever they wanted, so long as they created a sufficiently detailed thread that would generate sufficient interest amongst the user base. Once a thread is in existence with a sort of baseline, people then engage in topical discussions within the context of individual threads. It's an internet message board. It's not rocket science. And as such, it is also not ubiquitous. The opinions are not ubiquitous, and it is not a singular entity, but rather a place where individuals gather to do a thing, to discuss a common purpose. But it's only common insofar as each individual thread. You cannot, with any credibility, say that everybody on Kiwi Farms is interested in everything on Kiwi Farms, and it would be even less credibility to say that anyone on Kiwi Farms agrees with anyone else on any particular issue. They bring their own brand of infirmities, deficiencies, and superiorities to every single discussion that they engage in, and they are just people who have the freedom of being relatively anonymous and able to speak in that regard in the manner that they choose. So that is what Kiwi Farms actually is. So this is one of the initial problems with the lawsuit, is that it is brought, again, against Wise County Social Services and Joshua Moon. But Joshua Moon is brought in as the owner of Kiwi Farms, as if he is somehow responsible for individuals posting content on Kiwi Farms. Now, here are the 4 John and Jane Doe defendants. We have Jane Doe, number 1, the Jumping Dwarf; John Doe, number 1, Deadpool; John Doe 2, Carl DeGrosse; and John Doe 3, Rafael Ganowicz. These are just the screen names that they chose, and they have no indication of the actual users' identities. And that is something that Melinda was trying to get out of this lawsuit, the identities of these people, so that she could bring them in to the lawsuit in an individual capacity. She was not able to do this in a competent manner. And that is part of the reason that this lawsuit was doomed for failure. But we ran into a hiccup along the way that's going to require a little bit of extra explanation. We'll talk about it now. There's a part of the federal legal process that I must briefly explain to understand what happens next in this lawsuit, and that is service of process. This is the process by which you deliver the notice of the complaint that you have against someone to them in a legally sufficient manner. And that last part is critical, because it's not just a manner of somehow informing someone. You cannot, for example, tweet to someone or send them an email under most circumstances that would effectively notify them of a lawsuit sufficient for the rules of civil procedure. There is a process in place by which service must occur, and if that process is not followed, a lawsuit has not actually commenced. Now, in federal court, you actually file and petition the court to generate a summons. So you file the lawsuit with the court, you petition the court to generate a summons, and once that summons is generated and given to you, you go through some measure of affecting that process upon someone else. And there are specific ways that can get state specific on how to do it. We're not going to go into all of them. Suffice it to say, Melinda Scott delivered service of process in a particular way to Joshua Moon. Namely, Joshua Moon is allegedly not in the United States. Somewhere in Europe, I believe, but I don't actually know, and neither does anybody else really other than Joshua Moon. However, Joshua Moon has what's called an electronic mailbox at a Kinko's Copy Center somewhere in Florida. And Melinda Scott had the person serve the Kinko's store manager or store employee with the documents, and then those documents, in theory, should have been scanned and then mailed, probably emailed to Joshua Moon, or placed into some sort of inbox where he could take them. This, however, does not comport with the federal rules of civil procedure, nor does it comport with the rules of civil procedure in Florida, where this address and service is allegedly taking place, nor does it comport with the rules of procedure in Virginia, where Melinda Scott is filing this document in federal court. So, in all instances, Melinda Scott failed to effectively serve Joshua Moon. However, there is this weird issue with how the court systems work, where the court systems actually rely on people to let them know what's going on. And that gives them the opportunity to either lie, misrepresent, or be incorrect about something that has occurred in the case. And it typically requires the other party to then correct the record for the court, and then the court will hear out the two sides and determine who is actually correct. This leads to the first road bump, which has made this lawsuit significantly different from every other lawsuit Melinda Scott has filed against Joshua Moon. And that is that she very briefly won through a process called a default judgment. Now, a default judgment can occur in multiple instances. In this particular instance, how it occurred is that Joshua Moon failed to respond to the lawsuit at all. He was allegedly properly served because Melinda Scott filed paperwork that said he was properly served. So since service took place, Joshua Moon then has a limited amount of time to go ahead and actually respond to the lawsuit. If you do not respond to the lawsuit in the amount of time that is given under the rules, the court is basically forced to assume that you know of the complaint and you've chosen not to respond to the complaint because the complaint is correct. And therefore, you are liable at that point for whatever damages the court is able to find to rectify the situation. This is the process by which Melinda Scott would obtain this document. This is the default judgment. And we'll just take a quick peek at it here. It says the pro se plaintiff has filed a petition and affidavit for default judgment. Based on the pleadings and a review of the record, it appearing that the plaintiff is entitled to entry of a default judgment against defendant Joshua Moon, the clerk is directed to enter a default against said defendant pursuant to Federal Rule of Civil Procedure 55A. This means that the defendant, Joshua Moon, is not entitled to present any defense in the case, nor is he entitled to any further notice. Effectively, he has lost. He can no longer come in and argue his position or perspective. Right now, according to this document, he would be done. And many lawsuits actually do end this way. The next step is laid out below. As to a default judgment, the plaintiff, Melinda Scott, must prove any damages against said defendant resulting from the allegations of her complaint pursuant to Rule 55B. The clerk shall schedule a bench hearing before the undersigned in which the plaintiff may present sworn testimony and other proper evidence as to such damages. Because of the current coronavirus epidemic, the hearing shall be held virtually by Zoom, and this is signed by Judge James P. Jones on November 16th of 2020. At this point in the lawsuit, Joshua Moon has lost. Melinda Scott will be able to have a hearing to determine the scope of how much damage he has caused her through the cause of action, which we'll get to in just a minute, because it becomes important for the dismissal later on. But through this cause of action, damages are alleged, and those damages will now be proven out, and Joshua Moon will not be allowed to argue even a mitigation of those damages at this point in the lawsuit. But that, of course, would change very quickly when Joshua Moon retained counsel after receiving notice of this default judgment and then hiring counsel to argue that the default judgment is invalid. And this would kick off the bulk of the legal proceedings. Remember that this lawsuit was filed in July of 2020 and at this point was effectively over on November 16th of 2020. Now let's get to what the actual claims are and what happened in this lawsuit in regards to the other defendants as well. As stated before, Melinda Scott filed in forma pauperis. Now, let me explain what that means. That is a Latin term that means in the form of a pauper, someone who is unable to afford what they are looking for. And in this case, that is access to the American legal system. Your access to the American legal system is a constitutional right. And that means that if you are unable to afford it, then the government will go ahead and pay for it for you. Now, in forma pauperis can be combined in a deadly way with something called pro se litigation. And that is where a litigant is operating to represent themselves. And Melinda Scott has done both of these things. She is both a self-represented litigant and is also alleged and found by the court to be too poor to afford the basic filing fee requirements of federal court. Now, federal court is not cheap, but it is also not exceedingly expensive. We're talking about a couple $100s to get a case started, and then, a couple $100 depending on the things you file in the case. But each filing does come with a monetary cost. And there are several reasons for it, but I like to think that one of those reasons is just the mildest of deterrents for some people to say, do you actually mean to do what you're doing? You have to pay the court to show that you mean it. And so that means that with basically every motion filing that you have, you're going to be paying a little bit of money to the court. Except if you're in forma pauperis, and then all those filings are free. Now, why I say it's a deadly combination when combined with a pro se litigant is because a pro se litigant being unrepresented by an attorney is not always familiar, I would argue almost never familiar, with the actual processes that they need to be engaged in, which means that there will not be a competent professional to advise against a frivolous filing or to advise against an unwise filing. Not all unwise filings are ultimately frivolous. Now, Melinda Scott, because she has to pay nothing to engage in this process, and because she does not have competent counsel advising her on what to do and what not to do, proceeded to file tons and tons of documents. And again, that's why we're not going to go through all of them. She filed to have the judge recused. She filed motions to strike various things against Joshua Moon. She filed improper motion responses. She filed all sorts of documents that solely serve to extend the cost and time of litigation. And this is one of the reasons why the case took so long in and of itself. But we're getting ahead of ourselves. As a pro se in forma pauperis litigant, Melinda Scott sued, like I said, Joshua Moon along with the Wise County Department of Social Services and 4 John or Jane Does. We're not going to talk about the bulk of the lawsuit here against the Wise County Department of Social Services. That suit was dismissed when they basically claimed that they had sovereign immunity from, government immunity from the lawsuit itself. Since they had immunity under the law, the judge said, okay, well, this lawsuit is dismissed against them. And all that was preserved at that point was the ongoing default judgment against Joshua Moon. But what did she win default on? Here it is. Cause of action number 2 in her document, tort of intentional infliction of emotional distress. Now, this is a very, very particular cause of action, which suggests that the other party has acted either intentionally or recklessly in such a way as to cause extreme emotional distress in the complainer or the plaintiff, right? So to do something so egregious, so beyond the bounds of human decency, that it causes emotional distress that is so severe in the plaintiff that it causes them damage that can only be compensated through a monetary compensation. And the ways you prove out these types of damages are medical costs, loss of employment, loss of various relationships, loss of financial positions, or the costs of therapy and medical treatment that may accompany a recovery program from this type of distress. This is intentionally abusing someone through blatantly bad actions that wouldn't qualify as something like an assault or something like that. The idea is to cause a level of emotional trauma that is sufficient to merit a lawsuit. And that is what she is claiming that Joshua Moon engaged in along with the John and Jane Does. Now, again, we're not going to get in too deep with everything that happened here, but it really comes down to this. Number 69, defendant John Doe to Carl DeGrosse called Wise County Department of Social Services on or around June 22nd, 2020 with malicious intent. This defendant had the intent of harming the plaintiff emotionally through a child welfare agency call about the plaintiff. He believed this action would cause the plaintiff emotional distress because of statements the plaintiff made in a pleading which concerned a prior lawsuit against Wise County Department of Social Services the plaintiff had filed. Defendant John Doe 2 had access to this pleading through the postings on kiwifarms.net. Now, these distressing actions that followed all started with the distressing action of contacting Wise County Department of Social Services. Now, you'll notice what's absent in all of this is the specific actions of Joshua Moon. And that's because he's not really alleged to have participated in this with any sort of evidence other than him being the owner of the website. Since he owned the website and didn't take down the information that Melinda wanted taken down, she is saying that he is then responsible for the subsequent actions of others. This is not a solid legal theory, but it is the theory that she proceeded with. Now, at the end of the day, you cannot be held liable for the actions of others, only for the actions of yourself, unless those others are acting specifically at your direction, on your behalf, and with your authority if they become agents. Melinda did not really put forth a competent agency argument, so we're not going to really go into that. What's notably absent from this is the underlying issue that Melinda has sued Josh over multiple times and which is left out of this lawsuit cleverly by Melinda, and that is that she's actually suing because her information is up online and she doesn't like it. Prior attempts to get this information removed have been lawsuits over defamation and false light, in which she suggests that the things said about her online have not only been false, but have damaged her reputation and damaged her economic ability. And so therefore she should be compensated for them. Or the false light claim is a little bit different. It says that there are true statements that are being made that were private that are brought to light in a false way, and that the casting of the false light on the statements, while technically true, is set up in a way that would cause harm, and again is a false light. So it's to take a detail that is true, but to cast it in a way that is false to cause damage to the person. Now, these causes of action are notably absent from this lawsuit because those have already been litigated and Melinda Scott has already failed. For her to bring them in again would invite something called res judicata, which means we already did this, Your Honor, and therefore her case would be dismissed. So she added in a new cause of action and left out the old, but at the end of the day, this is what she's ultimately after. She's ultimately after that original claim. And this would be argued in some of the back and forth motion documents that we're not going to discuss right now. But that being said, this is the cause of action, that intentional infliction of emotional distress. So the court is left with the question of whether or not the particular action, in this case, the call to CPS and then the discussions that happened subsequent to that call, are enough to fulfill the four-part test for intentional infliction of emotional distress. Of course, they would ultimately come to the conclusion of no, but because of the default judgment, this was short-circuited, and this is what Joshua Moon was now responsible for due to his failure to respond to the default judgment. Of course, As the story goes, Joshua Moon retained counsel and then would no longer be responsible because he pointed out the critical flaw in Melinda Scott's original claim. And that critical flaw is that he was never properly served this lawsuit under the law, and therefore the lawsuit did not commence against him, and therefore he could not be held liable for the default judgment, and the judge would go ahead and reverse the default judgment shortly thereafter, and the lawsuit would then proceed back to the starting position and then move forward on the normal sort of timetable, which we'll talk about now, how that ended up on August 31st, 2021. Sorry, August 30th, 2021. Once Joshua Moon was able to get the default judgment overturned and then get the process sort of restarted from the beginning, they were then able to start arguing over the underlying claim in the case, which is the intentional infliction of emotional distress and Joshua Moon's role in it. Now, this case would never progress all the way to trial. It wouldn't even get to summary judgment because we got into the issue of whether or not there was a sufficiently complained underlying issue for the court to even address. The court, to be clear, dismissed this and said, no, there was not. And moreover, the court dismissed it with prejudice, which legally means that it cannot be relitigated. Now, does that mean that Melinda Scott will not file another lawsuit and attempt to relitigate this and other issues in the future? No, it does not mean that. I stated before that I believe she has some level of compulsion to participate in these sort of pro se lawsuits, an addiction, if you will, to this process, and an addiction to her own ability to try and articulate claims against her before a court of law. Some people get into a power trip with the legal system and believe that it is the appropriate vehicle for resolving their own life issues. I believe Melinda Scott is in that camp, and I think that is not, by the way, a criticism of her. That is an assessment, and I think that she needs to find a way out of it because I think it is wholly detrimental to her life, and I think this lawsuit and the several before it have created that sort of Streisand effect that she should be looking to avoid. Just because someone's talking about you doesn't mean you need to tell the entire world that someone's talking about you. And more importantly, people have been talking about other people for all time. Just now that it is cataloged and recorded on the internet, people find out about it with more frequency when they find out that they're being discussed somewhere. And so then they think that this should lead to a legal resolution. When for most people, if they're being talked about on some corner of the internet, and particularly if they're being talked about in a negative way, the healthiest and best response is frankly to just ignore it. Because it is not profitable for the average person to engage in a small corner of the internet and potentially making it into a big corner of the internet. And that's what Melinda Scott has done for the past several years to her detriment. So my advice to her would be to just stop, lady. Just stop. This is not helping you. But as we were discussing, we got into the arguments over the next course of the lawsuit as to whether or not there was even a claim that the court could litigate. The court would ultimately decide no. Now, this case has 63 docket items out there. That means there are 63 either documents or specific notable actions that took place within the court. To go through all of them would take hours and hours and hours, and we're not going to do so. Remember, I mentioned earlier that Melinda would go on to file frivolous motions, frivolous motion responses, meritless documents, claims that the judge was sexist, claims that the judge needed to recuse himself due to his sexism, etc., etc., etc. And these increased the cost and scope of the litigation far beyond what needed to take place, and that was their ultimate purpose. So again, going through all of them would take way too much time. We're not going to do that. But suffice it to say, the underlying argument is that Melinda Scott failed to sufficiently plead the cause of action. She failed to provide a factual basis, even if taken entirely as true, that would lead to Joshua Moon being responsible for what she is claiming happened, the intentional infliction of emotional distress. And the judge would issue an order on August 30th of 2021 to that effect. Let's take a look at this order because he has some words for Melinda in here that are very, very important. All right. The defendant sued for intentional infliction of emotional the defendant, comma, sued for intentional infliction of emotional distress, has filed a motion to dismiss. For the reasons set forth herein, I will grant the motion and dismiss this action with prejudice. Melinda Scott, a frequent pro se litigant in this and other courts, filed this action in forma pauperis, asserting two separate causes of action. Now, again, this is just giving the procedural background of the case, but listen to how the judge is actually framing this discussion and framing what has gone on here. He's pointing out that she is a frequent pro se litigant, a detail that was not necessary. He could have said a pro se litigant, but he points out that she is frequently doing so and has filed in forma pauperis, which is going to lend to his overall tone that this lawsuit is frivolously filed at basically no risk to the filer, but at cost to the defending party. The first, against the Wise County Department of Social Services, was previously dismissed on the ground that it was immune from suit under 42 U.S.C. 1983. The second claim, a pendent state cause of action, is against defendant Joshua Moon and 4 John or Jane Doe defendants. It is asserted that Moon is the owner of the website in which John or Jane Doe defendants posted derogatory remarks about the plaintiff, and that they and Moon, quote, each are responsible for contributing to the malicious phone call made to the Wise County Department of Social Services that resulted in a home visit to the plaintiff's house on June 22nd, 2020. The plaintiff alleges that as a result, she experienced extreme emotional distress, including anger and rage. The plaintiff has sought to sue Moon twice before in this court and several times in other courts as well. In the earlier pro se actions, she also complained of alleged defamatory web postings for which she asserted Moon was responsible, causing her emotional distress. And this is going into that res judicata argument that was raised by Joshua Moon's lawyer. In the present case, the plaintiff adds the allegation that Moon contributed to the phone call to Department of Social Services. Now, this is baseless. There is no way to, or she does not suggest in any way that Josh could materially contribute to a phone call. She didn't say he made the call. She didn't say he spoke on the call. Under Virginia law, a plaintiff alleging intentional infliction of emotional distress must prove the following elements. First, the wrongdoer's conduct was intentional or reckless. Second, the conduct was outrageous and intolerable. Third, the alleged wrongful conduct and emotional distress are causally connected, and the distress is severe. The second element requires that the conduct was, quote, so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. A brief commentary on that. It is very hard to do this when someone is following an assigned government process. Like it or not, the Child Protective Services complaint function of the government has set up a format for which people can call and lodge some sort of complaint or concern in the interest of protecting a child. Overcoming that basic default assumption that people are doing this for the purpose of protecting the child requires a showing, because we don't want any phone call to CPS to be regarded as so extreme and beyond the bounds of decency that it's not tolerated in civilized society. We can't have that actually happening. And so with that, we have a big hurdle that Melinda was almost definitely not going to be able to overcome. To overcome this hurdle, she would have to show that not only were the actions taken in bad faith, but they were taken in such bad faith that these types of phone calls would be utterly intolerable in a civilized community. Participation in one's government is almost never considered utterly intolerable in a civilized community because participation in the governmental processes is the hallmark of what government determines to be civilized community. There are cases on this that basically discuss people filing lawsuits over and over as a form of harassment, and that not even being able to measure up to intentional infliction of emotional distress, because that is the process by which people are allowed to engage the government to resolve an issue. And it's hard to make that into an action that is so beyond the bounds of decency. We're usually talking about actual damage being done to someone that would cause them severe emotional distress. The kidnapping of a beloved animal or a child or something like that would be the types of things we're talking about. Things that are not allowed by common decency. Finally, the judge says the plaintiff's allegations do not meet the test of Virginia law. Moreover, it is clear that she is speculating that Moon was involved in some way in the call to local Department of Social Services. You can't just speculate in a federal lawsuit. You have to provide some factual assertion that can then be challenged by the defendant. You have to say they participated in this way by making the phone call at this time, by speaking on the phone call with the person. You have to allege some way that the person did the thing. You can't just sort of guess at it. I will grant the motion to dismiss as to Defendant Moon. Because the plaintiff's allegations are wholly insufficient, I will also dismiss the claims against the John and Jane Does pursuant to 28 U.S.C. 1915 E2B2, particularly in light of the plaintiff's repetitive, meritless filings on this subject. I will dismiss this action with prejudice. It is ordered that the motion to dismiss is granted. A separate judgment will be entered herewith. And that was signed by Judge James P. Jones on August 30th of 2021, bringing this saga to its ultimate conclusion. Again, well over a year after the initial claim was filed. The last document in this case was actually filed in March of 2021, and it has taken this long to get around to this decision. It is the right decision. The claims are meritless. You can think what you will about Kiwi Farms, how they conduct themselves, what type of information is stored there, and all of those are separate arguments. In fact, you can think what you will about Joshua Moon, and many people have plenty of negative opinions about him. That being said, this is not the proper cause of action. It was not properly argued, and the defendant was not harmed in this way. Or the plaintiff, I should say, was not harmed in this way. And the plaintiff in this case has a history of filing these vexatious and frivolous lawsuits. And it all stems from the fact that somewhere someone talked about her in a way she didn't like. And if everybody were to file a lawsuit every time something like that happened, there would be nothing else done in the courts other than that. But that being said, I promised you a little tidbit that makes this just a little bit sweeter, a little topper for your dessert. And that is the fact that Judge James P. Jones entered into a semi-retirement that is available for judges who meet certain statutory requirements. They're a certain age, they've been a judge a certain amount of time, they've taken on a certain caseload, and he entered that semi-retirement on August 30th of 2021, making this, I believe, the last judgment that he would file as an active judge on the federal bench. Now, he can still engage in other cases and take on a reduced caseload as what's called a senior judge. It is a process of semi-retirement. It may not be the final judgment he ever issues, but I think it's a nice punctuation on the fact that this was probably the last judgment he ever rendered as a active U.S. District Court judge. But that's what I think about it. I hope you found this informative, thorough, explanatory, educational, and hopefully a little bit entertaining. This is a subject that I've been talking about for quite a while as this case developed, and I'm happy to bring the news of the conclusion in this relatively long video to you today. Thanks for hanging out with me. Drop a comment down below. And if you know people who are interested in these types of subjects, please go ahead and share the video and let them know where they can get kind of a rundown of the case with a little bit of legal explanation that hopefully normal people can understand. Until next time, thanks for watching, guys. Peace. Peace.